You may not even realize it, but this could be a possibility. Let's say you have told the truth in your application, 100% truth without hiding literally anything, yet you have received a procedural fairness letter just because you have told the truth, right? Is it really a possibility? 100% yes. And I could confirm from my experience that I have seen at least 15 to 20 different cases in the last 3 months alone where this situation exactly is being replicated. Let me tell you how does it really happen, right? So let's say you are living in with your partner here in Canada, okay, both of you. Let's say you came from India, you are living in with your partner here in Canada without realizing, now this is the crux, without realizing that you may potentially apply for a common law relationship PR application as well. So let's say one of the partner receives the PR without declaring the spouse or the partner or the girlfriend for that matter, without even realizing that she could potentially have been added to that application or would have been declared in that application as a common law partner. You apply for your PR thinking that, well, she's only my girlfriend, I'm not here and not yet a PR. I will apply for the permanent residence only after my PR is confirmed, right? So I'll sponsor her after my PR is confirmed. So she's not been declared or added into your application. But when you lodge the spousal sponsorship application, you practically provide all the proofs, let's say for the previous 5 years. Officers would then question your obviously truthfulness, that why did you not declare your wife into the PR application? Why did you not declare her as your common law partner? And then officer may accuse you of taking advantage of the act. So this is a classic example where you tell the truth and yet receive a procedural fairness letter. So the crux of the matter is, now I'm not saying that you do not tell the truth. Obviously you have to be truthful in your application all throughout, that's given, right? What I'm saying here is that if you're lodging a spousal sponsorship application or a family class application, in meaning that whether that application is in Canada or outside Canada, if you guys have cohabited prior to the marriage, okay, make sure to consult with somebody before you lodge that application, because there are a lot of ifs and buts that are surrounded with those kind of applications. And if you are unable to convey the truth, or if you have conveyed the truth to the extent that you otherwise shouldn't have, again, this is not a misrepresentation, okay, you may potentially receive a procedural fairness letter. And trust me, this is one of the most difficult procedural fairness letter cases to handle, because if the officers have made up your mind that, well, she is not a member of family class in this particular example, they're not going to approve your application. And I have also seen some of the cases where they have issued an inadmissibility letter or a ban letter. So before, if you have cohabited and if you're lodging a spousal sponsorship application or a family class application, please make sure to understand the law, understand regulations 4 that talks about cohabitation and all those stuff, and then only lodge that application. So we as an organization, we obviously deal with the procedural fairness letter cases, a ton of it, and we also deal with a lot of spousal sponsorship application cases, right? So if you need our assistance, make sure to visit the website nuvonation.ca, book a relevant professional consultation, and I'll be more than happy to have a case-specific discussion with you. Hope this helps. Bye now.